In Arun Suri versus ED case that was presented to the Delhi High Court, a big question was that can Enforcement Directorate seize such property which are ancestral nature even if they are not directly connected to the proceeds of crime, even though these properties were purchased long time before allegedly crime has happened. In this powerful ruling, Delhi High Court has said yes, such kind of property can be attached by Enforcement Directorate if the actual proceeds of crime is missing and the property that is being attached is of equivalent value of the amount in which crime has been committed. So let us try to understand what is this entire ruling all about. Now the matter in the front of Delhi High Court was related to the ancestral property. We know that Arun Suri versus Enforcement Directorate has raised a key legal question under the PMLA. We know that Prevention of Money Laundering Act that was brought in year 2002, later amended in 2005. We have seen that Enforcement Directorate, a central government agency, has been given a power that in case of proceeds of crime being harbored by a particular criminal, the equivalent value, equivalent property can be attached. That means it can be seized and recovery can be done. Now, three questions were in front of Delhi High Court that was raised by Arun Suri and his lawyers. So, the first question was that can ED attach property acquired before crime? Because in this case, Arun Suri has stated that the ED has attached such property which actually belonged to his father, which was bought in 1991, almost a decade before alleged crime has been committed by him. Second, can ancestral property be confiscated? Because two situations are there. One, the criminal or perpetrator or alleged criminal or perpetrator, we can say, if he has bought a property before committing the crime, and second, if property belongs to his forefather. Third was, what if actual proceeds are untraceable? What would be the options left with Enforcement Directorate? That means there is a clear case of money laundering, there is proof, but now the money is no longer available. Maybe the accused has put money in converted money in foreign currency and has sent it overseas. In that case, recovery becomes difficult. So, what are the options available to ED under PMLA? Now, if you look at the facts of the case, we have discussed property was purchased in 1991 by his father. Alleged crime occurred decades later. That is the ground on which appellant, that is Arun Suri, claimed that property does not belong to or is not directly related to the crime or criminal activities. It cannot be considered as a proceeds of crime. And thus, under the section 5 of PMLA, only such property which is tainted in nature should be only attached by Enforcement Directorate. But this alleged this ancestral property, since it does not qualify as tainted property, ED has no right to attach it or seize it. Now, if you look at the relevant provisions of Prevention of Money Laundering Act 2002, two major sections we have to keep in mind here. First is the section 5. Under section 5, I told you there is a provisional attachment power given to the enforcement agencies such as Enforcement Directorate, and second is the important section, that is 2(1)(u), section 2 subsection 1 and clause u. There what actually constitutes the proceed of crime is clearly been defined here. However, courts across the different judgments and across different time period has taken different interpretation of this clause. That is also we are going to discuss in the coming slides. It includes value of such property that covers equivalent property within India. That means Delhi High Court has stated that under section 5, the attachment power given to ED does not only qualifies over the tainted property or direct proceeds of crime, but ED can attach any property which is having equivalent value and it is located within India, especially in such cases where the money has been laundered and has been sent overseas. So, what has been the overall features of this particular ruling as far as Delhi High Court is concerned, because it's very important ruling as it is going to have ramifications and may serve as a precedent for other such rulings in different parts of India and courts as well. So, ancestral nature just does not guarantee immunity and grant immunity. That is the first stand taken by the Delhi High Court. Just because the properties of ancestral nature, it does not mean that ED or any government agency cannot attach it. That is invalid. Second, ED may attach property of equivalent value. That is very important point to mention here, because it's not that ED can attach any property, but those property which are having equivalent value to the tune of crime that is being committed here. Third, it ensures accused cannot enjoy the proceeds of crime as such. And fourth, alternative attachable property concept has been brought by Delhi High Court in this particular ruling. So, very important judgment. Now, the precedents that Delhi High Court relied upon to come up with this verdict, let us take a look at them also. So year was 2019, a case was brought in Supreme Court, that was Deputy Director versus Axis Bank. In this particular case, the court interpreted section 21U that we have discussed there. It has stated that the property that is alternative in nature, it can be attached, and if actually the money cannot recover, in that case it can clearly be attached as such. Second is Prakash Industries versus Enforcement Directorate 2022. Here also the court has taken the stand that not completely immune, any property, any asset is not completely immune if equivalent value of this property can be ascertained by the department. Third, in the Vijay Madan Lal Chaudhary case that was again brought against Supreme Court 2022, here Supreme Court has looked into the constitutionality of the PMLA Act, and the constitutionality of PMLA Act was upheld here. Supreme Court has clearly taken a stand that all the provisions of the PMLA Act are not something that is basically against the constitutional spirit and all. So they are not ultra vires, they are very, very valid in nature. And overall, in these judgments, the courts have taken a relatively broad interpretation of value of property here. Value of property here means that just the tented property is not something that ED can attach, but other properties also. However, there has been several judgments across different high courts of India before as well, which has taken a divergent stance as compared to these pro stance as such. Some of the judgments let us try to understand. So first judgment was Pavana Dibbur versus Enforcement Directorate, Supreme Court 2023. Here Supreme Court has clearly stated that only those property which is directly a result of proceeds of crime which has been brought after the crime has been committed should be attached by ED. Any property which is of ancestral nature, which has been brought long time before the crime has been committed, should not be attached, cannot be attached. So that is something which again put a big question mark. Second is Seema Garg versus Deputy Director, Punjab and Haryana High Court 2020. Similar matter was brought in again. The High Court has taken a similar stance that only tented property can be attached by Enforcement Directorate as such. Andhra Pradesh, Patna High Court, they also have taken similar stance as such. So if you look at all these stands taken by the High Courts, we can say that these decisions are based upon a narrow interpretation of the attachment approach, narrow interpretation of the power given under section 5 to the Enforcement Directorate, because here these judgments refer that ED's power only is over the tented property, over the property that is directly a result of proceeds of crime. So overall, if you look at this entire discussion, we can say that in the judiciary, we have two views that has emerged as far as this particular situation is concerned. One is the broad view, where judgment delivers is clearly establishing the fact that equivalent property anywhere across India can be attached if original money cannot be traced and recovered. Second is the narrow view that says that only directly linked property, directly means directly linked to the crime that is committed by the perpetrator, can be only attached by Enforcement Directorate as such. So the issue of pre-crime acquired assets is again a question that has been raised by this particular this petition by Arun Suri in Delhi High Court. So as you can see that courts are not united here. Courts and judiciary have not taken and given a similar verdict. They are given two different type of verdict. So definitely a legal uncertainty still persists as far as this particular regard is concerned. This particular situation is concerned. Article 300A, basically it is a right to property that can be also brought in here. It is a legal right, but nonetheless it is right. Risk of investigated overreach. Talk about some lawyers have stated that such decisions basically give power to ED to attach any property, and it is example of investigative overreach. But overall, the Delhi High Court judgment is trying to maintain a balance with enforcement that is required to address the crimes of black money, money laundering. Many times these money are also used to fund terrorist activities and anti-national activities as well. And on the other hand, it also has to balance the right a person enjoys in India that is given to him by the Constitution of India, and that's how the presumption of innocence clause also come into existence, that whether any property that was acquired before crime was committed, should that be considered as an innocent property free from any kind of ED's interference and attachment, and should it also be brought under the overall umbrella of ED's investigative and attachment power. So as we can see that uncertainties exist, and many experts claim that in the near future we might see again intervention of Supreme Court of India, because if you talk about this particular judgment of Delhi High Court High Court is not bound by judgments of other high courts across India, no matter whatever judgments they have given. Delhi High Court is bound only by the judgment given by a division bench of larger size of the same court, or judgment that is given by the Supreme Court of India, a clarificatory judgment, a definite judgment in this regard, then only that will be applicable to the future decisions of Delhi High Court. So uncertainties persist. We have to wait, watch and see that whether the matter is raised and then put forward to Supreme Court or not, and if it is put forward to Supreme Court, what is going to be its final and ultimate decisions. That's all about this particular video. If you like the video, please hit like button, share it with friends, as well as subscribe to the channel for more such content. Thank you very much.